Okay, today what we're going to do is a little something different. We're still going to take notes. You have your note packet, and this is going to be just like if I was in front of the classroom giving your notes and everything, only instead of me being in front of the classroom, you're going to get your notes off of YouTube today from a flipped lesson plan that I made. Now, there are going to be some times when I go into Microsoft Word and I'm going to type on Microsoft Word. That's just as if I was writing on the board. So if I type something in Microsoft Word, you write it down in your notes just like if I was writing it on the board. Okay? So let's go ahead and get started. Today we're going to be talking about the judicial branch.
Well, you certainly know.
You can see there are 3 sections in this, so it's not going to take us very long to get through this chapter. The first section is equal justice under the law. Section 2, we're going to look at the federal court system. And then finally in Section 3, we're going to look at the Supreme Court.
All I know is that I'm having an Amsterdam good time, yes. I just want you to be my everything. And now...
So here are your objectives. We're going to look at how does majority rule affect the making of laws and why is obeying laws important? What are the 4 types of laws? And finally, what roles do the courts play in the United States?
You know, I haven't been on an actual...
So, why do we have laws? Well, the laws that we have are mainly because that is what the majority of people want. Not everyone likes every law, and most people don't like laws when the law applies to them. Otherwise, they're happy with the majority of them.
Woodrow Wilson said some 100 years ago that the Supreme Court is the balance beam of the whole constitutional system. Yet, some 100 years before that, in 1787, Alexander Hamilton called the judicial branch the least dangerous branch of the United States government. Well, how can this branch go from being virtually powerless to being one of the most influential within the constitutional system? Taking a look at the creation of this branch might help us understand why.
Article 3 of the Constitution gave America its judicial branch, when it said,
"The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." Which means, hey everybody, how's about a government branch that interprets our laws?
When this part of the Constitution was first written, not all citizens agreed to this court system. There were 2 main schools of thought, the Federalists and the Anti-Federalists. Alexander Hamilton was a Federalist. He and all his Federalist buddies saw the new Supreme Court as the least harmful branch in the government. But the Anti-Federalists weren't so blasé about the whole thing. The Anti-Federalists felt that a branch of government made up of people with a lifelong tenure was dangerous, especially since they had the power to interpret the meaning and importance of the supreme law of the land. Supreme Court justices would be justices until they died or stepped down from office according to the Constitution.
well, the Anti-Federalists did have a point. Article 3 was a bit vague when it came to the structure of the Supreme Court. That's why, in 1789, the Judiciary Act of 1789 was passed.
The Judiciary Act of 1789 established the 3-tier structure of the federal court system. Those 3 tiers include the federal district courts, the circuit courts, and the Supreme Court.
Before we get any deeper into the world of the judicial system, you should know a quirk of the American legal system.
Specifically, the American legal system has made several names for itself. The first name is the dual system. You see, while there are all those federal courts and the courts of appeal and the Supreme Court, there's also another arena for law in this country, and this is thanks to the dual system.
The dual system consists of the federal court system we just outlined and the individual judicial systems at the state level.
Secondly, known as the 3-tiered system, the American judicial system contains 3 different levels of courts within both the federal and state levels. Each tier has a different jurisdiction.
They are the trial courts, the appeals courts, and the Supreme Court.
Let's see how each of these courts fit together to form the big judicial system. The federal district courts are the lowest level courts on the federal tier. There are over 94 federal district courts in the country and at least one in each state. What does the authority of the federal district courts include? First, those cases that deal with a federal question whose issue is based on a claim within the U.S. Constitution. Second, cases where the plaintiff or the defendant is the federal government. And third, cases involving diversity of citizenship, meaning cases with people from different states or where the issue involves more than $50,000.
It's in the federal system where most of the big legal work of America occurs. But what happens when the people involved in a case within the federal district courts aren't happy with the outcome? They can move on up to the second tier and take their griping to the circuit courts in the form of an appeal.
The circuit courts, also known as the appeals courts, include 13 courts in the United States. These are courts which have no original jurisdiction.
Now, original jurisdiction refers to a court's authority to hear cases for the first time at the trial level. This is what the federal district courts have.
Instead, the appeals courts have appellate jurisdiction, which refers to the authority to review a case which has already been decided at the trial level. One thing to remember is that the appellate courts determine what laws apply to a case. District courts, on the other hand, determine the facts that decide a case. Appellate court cases are usually heard by a panel of 3 judges with no jury. District courts, on the other hand, are made up of 1 judge, and in the case that a trial is held, a jury of the defendant's peers.
So, getting to the appeals court is like getting another chance in the bull ring. There are 2 types of cases heard at this level. Those involving cases from federal district court and those involving issues in federal administrative agencies.
But what happens if after you've made it to the appeals court, you're still not happy with the decision?
You can try your best to take your case to the third tier, the Supreme Court of the United States. The Supreme Court of the United States includes 9 members, 1 Chief Justice, and 8 Associate Justices.
So laws are passed for the good of all citizens. Again, in order for a law to become a law, not everyone has to agree to it. And in fact, those that decide, not all of them have to decide yes or no. It just simply has to be a majority vote. So you're always going to have some people that are not going to agree with every law that is on there. But we are a democratic society, and in a democratic society, majority rules. Majority just simply means more than 50%. So, but most laws that we have, the large majority of people do agree with those laws.
Boo, frickety hoo! I had the best grades in the class and I didn't get diddly squat.
Because if we didn't have laws, anarchy would develop. We would have total chaos, and it would be like the days of the old Wild West where everyone was just taking the law into their own hands, and that's not a good way you want your society to try to function.
Hope I'm not disturbing you.
Can I try it really quick?
Now, there are 4 types of laws in the United States. The first one is what is called statutory law. And these are most laws, and these are laws that are passed by lawmaking bodies. Next, you have what is called common law. Common law is when judges' decisions are based on common sense, experience, and practice. And also within common law, we also have what is known as, and here's where you need to write this down, a precedent, an earlier decision based from a judge. So what happens is that if a judge has to make a ruling on a case and it's a very unique case, The judge can't find any other cases like this, and so the judge then makes a ruling, gives their reason as to why they ruled the way they did. Well, what has happened is the judge has just set what's called a precedent, not a precedent, a precedent. And this is when, so what will happen then is that let's say that there's another case that happens to be very similar to the one this judge just ruled on. Well, instead of that judge trying to reinvent the wheel and have to go from scratch, they'll say, well, I know of a case like this from the past, and this is how this judge decided, so I'm going to judge that same way. It's no different than, let's say, those of you that maybe have older siblings, and an older sibling has done something, they got into trouble for it. Now here you come along and you ask your parents if you can do something similar. Maybe you want to go out for the first time, you want to take the car, and some friends are going to go watch Pierce compete somewhere, whatever the case may be. Well, last time an older sibling went and did that, they ended up getting in trouble. And so now your parents automatically say no to you, even though you haven't done anything wrong. Well, that's kind of like a precedent. Your older sibling set a precedent when they went to do something and they got in trouble. So now your parents are assuming, well, you're just like them, so you're probably going to get in trouble too. So they just go ahead and decide no, even before you have a chance to even try to do anything.
Hope I'm not. Can I try?
The next type of law is what is called administrative law. Administrative laws are created by government agencies. So those regulatory commissions and independent agencies that we talked about last chapter, any laws they make would be examples of administrative laws. And then finally, there's constitutional law. And this one's pretty self-explanatory. This is a law that is based on the Constitution and how it is interpreted by the courts.
I'm gonna call the cops.
You know, gold member, I do.
Now, next thing we're going to look at is how courts are used and how everything plays out. That is, if you were going to have to go to court for whatever reason, what is the process? How does this all work? First of all, the role that courts play in the United States is to settle disputes. Oftentimes, most disputes, if you have two people that disagree on something, maybe somebody was going to buy something from someone and they felt that they were not treated right. Maybe the person tried to cheat them. So the person that felt they were cheated, well, now they're going to take them to court. These cases will happen in what is called a civil court. Then there's criminal court. Criminal court obviously is when someone has committed a crime. The big difference between civil court and criminal court is that in criminal court, the jury must be unanimous when they make a decision, which means every member of the jury has to say, yes, that person is guilty of the crime they are accused of. If it is a civil court where maybe you're suing someone, there it just has to be a majority of the jury feels that yes, you should get what you are asking for, or no, you should not. And so that's a huge difference between civil court and criminal court, between a unanimous decision and a majority decision. Another job of our courts is to assure that equal justice happens in all trials that occur. Now we're going to look at the trial procedure, but we're going to actually start this on another video.